not elbow out Indian farmers because they are more. Yeah? Great. Now let's look at another article. BJP MP's ludicrous remarks are not worth contempt action, says the Supreme Court. We have Article 19, Clause 1, Clause A, which talks about freedom of speech and expression. And since I was talking about Article 19, I missed out one point which I suddenly realized. The Supreme Court said in the Rohingya case that if Article 14 and Article 21 applies to everybody, because Article 14 which talks about right to equality, because these Rohingyas may claim, why are you discriminating against us?
और आर्टिकल 21 तो बहुत बड़ा है, मतलब बहुत बड़ा बेस है कॉन्स्टिट्यूशन का.
And we have right to life and dignity as
Yes,
well,
right to life and
which you will be
dignity.
violating if you deport us to Myanmar. Gujarat High Court, Delhi High Court previously has said that inherent under Article 21 is the principle of non-refoulement. So even if India is not a signatory to United Nations Convention on the Status of Refugees, even then, since Article 21 talks about right to life, we still will have to follow the principle of non-refoulement. But the Supreme Court has said, even if Article 14 applies to everybody, Article 21 applies to everybody, but Article 19(1)(e), which is the fundamental right to reside and settle anywhere within the territory of India, this is available only to the citizens. And if these Rohingyas are foreigners, the government, the central government has the right, has the authority,
To settle them.
ultimate authority and power to deport.
Yes.
That's what I realized when I was talking about Article 19(1)(a) of the Constitution, which talks about free speech. But it is not an absolute fundamental. The freedom of speech and expression can be restricted under Article 19, Clause 2, on the grounds of 8 grounds are mentioned on the reasonable restriction. And one such ground is contempt of court. But keep in mind, this phrase contempt of court is not defined in the Constitution. This contempt of court can be either civil contempt or it can be criminal contempt. In fact, this is a question that was once asked in your prelims examination. This has been defined by the law passed by the Parliament in 1971 called Contempt of Courts Act 1971. So although your free speech can be restricted on the grounds of contempt of court,
सही
the
है.
Constitution has not defined what is contempt of court.
क्या
It is the Contempt of Courts Act 1971 which classifies contempt into civil contempt and criminal contempt.
Right.
What is a civil contempt? For example,
सिविल
I had a
कंटेम्प्ट मतलब
hearing
बेसिकली
before
जहाँ क्रिमिनल कंटेम्प्ट ना
And the
हो,
court said
लैंड्स का हो
that
ना.
on the next date of hearing, which is 10 days from now, let's say on the 1st of June, you have to appear before us again. Or the court gave me a directive that you hand over these documents to someone else. This is a directive. What if I deliberately, willfully disobey the court order? This is civil contempt. That means if I have given an undertaking to the court that I will pay this person 100 crores which I owed him, and even then I am not paying, I am disobeying the court order, this is civil contempt. Deliberately, willfully disobeying the court order or violating the undertaking that you have given to the court, that is civil contempt. And the courts normally take a lighter view of the civil contempt. Maybe you will be reprimanded, but then you will have to abide by the court order. Because abiding by the court order is not an exception. It's the rule that you have to follow. But criminal contempt is something which is taken very seriously by the court. What is this criminal contempt? If you scandalize the judge,